Ladies and gentlemen, welcome to the National Constitution Center. It's such a pleasure to see you. I'm Jeffrey Rosen, the president of this national treasure of an institution. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the US Constitution on a non-partisan basis. And today we have a real thrill. We have the two lawyers who argued the most important privacy case of the term, and perhaps we'll soon find out of the decade once the court decides it, here to discuss the best arguments on both sides of the case weeks before the court hands down its decision. Now, because of this remarkable opportunity that we have, and the fact that these great lawyers have honored the NCC by discussing the case before it's actually come down, they won't be as free to evaluate arguments and to muse in an academic fashion because they are here as advocates, not as professors. But they will be as candid as they can in describing the best arguments on both sides of the cases, and then I will welcome your questions, although I hope you will not ask them how they expect the court to decide, because that's the one thing that they're not allowed to talk about. Before introducing them, I'll just put in a brief plug for our incredible roster of town hall programs that are coming up over the next 2 weeks. On Friday, David Boies and Ted Olson will be here on June 20th to discuss their new book about marriage equality. The next week, on June 24th, Lawrence Tribe will be here to discuss his new book about the Roberts Court. And on June 26th, we have a blockbuster debate co-sponsored with our friends at Intelligence Squared about whether individuals have an unlimited First Amendment right to spend as much as they like on their own campaigns. It will feature Floyd Abrams and Nadine Strossen, two leading civil libertarian liberals, arguing against restrictions on campaign finance spending, and in favor of the motion Burt Newborn and Zephyr Teachout, who I think is going to be running for the governor of New York. So that's going to be an incredible evening on June 26th. Please join if you can. Ladies and gentlemen, let me introduce two of the greatest lawyers in America who were on opposite sides of the Supreme Court case involving cell phones. Jeffrey Fisher is professor of law and co-director of the Supreme Court Litigation Clinic at Stanford Law School, a leading authority on Supreme Court practice, nationally recognized expert on criminal procedure. He's argued 22 cases in the Supreme Court and is a clerk for John Paul Stevens. Justice Stevens was here just the other week and did a wonderful job, and Judge Stephen Reinhardt on the U.S. Court of Appeals for the Ninth Circuit. Edward DuMont became Solicitor General of California in January 2014. He serves as the chief appellate lawyer for the Department of Justice of California. He's argued 19 cases before the U.S. Supreme Court, most recently Riley versus California, which we'll be focusing on today. He's been an assistant to the Solicitor General at the U.S. Department of Justice and has also been acting Associate Deputy Attorney General. He was a clerk for Judge Richard Posner of the U.S. Court of Appeals for the Ninth Circuit. This is just an astonishing dream team of constitutional advocates. Please join me in welcoming Jeffrey Fisher and Edward DuMont. As those of you remember either from law school, if you went to law school, or from The Paper Chase, if you remember that old movie, Professor Kingsfield always begins by saying, "State the facts, Mr. Hart." So we have to know what were the facts of this case, U.S. versus Riley, that the Supreme Court heard recently. Jeff Fisher, since you brought the case to the Supreme Court, tell us the facts of U.S. versus Riley and what the constitutional issue is.
I'd be happy to, but first, I just want to say thank you so much for including me in this and that overly generous introduction. What an inspiring place to be. It's just fabulous to fly across the country and spend a day at a place like this, so thanks for having me. So I represent David Riley in the case pending in the court right now. The facts of the case arise from an ordinary traffic stop in San Diego. Mr. Riley was driving one morning. He was a local college student. And was pulled over for having expired tags. The officer then ran his license and found out he had a suspended license, at which time he decided to impound Mr. Riley's car. During what's known as an inventory search to assess the contents of the car before the impound, officers found two two firearms that he was not allowed to be possessing. At that point, Mr. Riley was put under arrest. And as is customary when somebody's put under arrest, the officer did a pat down of his person to see what he might have in his pockets or such. And among the other things, found a cell phone in Mr. Riley's pocket. It was a Samsung smartphone, an early model to compete with the iPhone, called an Instinct. At that point, the officer on the scene looked at a few text entries on the phone. So opened the phone, started looking through it, looked at a few text entries, and a few of the text entries indicated to the officer that Mr. Riley might be involved in gang activity. And so as he was arrested and brought to the station, that officer contacted another police officer in the San Diego Police Department who specializes in gang investigations. And a couple of hours later, after Mr. Riley had been processed at the station and unsuccessfully questioned, the gang officer went to the property room and grabbed Mr. Riley's cell phone, which was still on, still operational. Many people asked whether there was a password associated with the phone. It was not password protected, as many people still don't, and even fewer people back then did. This is a few years ago. At that point, the officer looked through, as he later said, a whole lot of stuff on the cell phone. In other words, he downloaded the information, went through photos and videos and the like, and among other things, found some photos and videos indicating, again, that Mr. Riley was involved in gang activity, and even more interesting to the officer, saw photos of Mr. Riley posing next to a red Oldsmobile. And that, in a red Oldsmobile, caught his attention because a few weeks earlier there'd been a drive-by shooting. Nobody was killed, but shots fired out of a car, and they thought that car had been involved in it, and therefore now, because of the search of the cell phone, the officer believed that Mr. Riley may have been involved in this completely separate crime from which he was arrested. The investigation went forth, and ultimately the officers in the state charged him with being involved in that drive-by shooting and used the evidence from the cell phone against him at trial, ultimately obtaining a conviction. I suppose the only last fact I should highlight here is that at no time during any of these searches of Mr. Riley's cell phone, neither the one at the scene nor the later one at the police station, did the police ever apply for or obtain a warrant. And that ends up providing the grounds for the claim Mr. Riley made in the trial court. First, that it violated his Fourth Amendment rights to search his cell phone without a warrant. Remember, the Fourth Amendment says that the police and government agents cannot engage in any unreasonable searches and expresses a preference for obtaining warrants before engaging in any search. Mr. Riley argued that the search of his cell phone therefore was unreasonable because it unduly invaded his privacy without obtaining a warrant. He lost that argument in the California courts, in part because a few years earlier the California Supreme Court had ruled, or actually as the time he played in his case, it was quite recent, but the California Supreme Court had held that when somebody is arrested, officers could not only seize cell phones, but search them thoroughly, the digital contents thoroughly without a warrant. And so applying that rule in the California system, Mr. Riley lost his Fourth Amendment argument as it went up through the California courts. And I suppose the last thing I'll say, and let you ask a follow-up or Ed jump in, is it's at that point that I got involved in the case with my Stanford Law School clinic. We filed a petition asking the U.S. Supreme Court to hear the case on that Fourth Amendment issue because other states and other federal courts of appeals had come to the opposite conclusion of the California Supreme Court. So we asked the Supreme Court to solve the conflict in the lower courts over the requirement of whether a warrant is required, at least as a general matter, to search the digital contents of cell phones.
Wonderful. Thank you for that crisp and helpful summary of the facts. I'm going to ask Ed, first of all, are there any aspects of Jeff's factual statements that you'd like to amend? And then tell us, what is the government's position in this case? Why is it that you believe that a warrant is not required to search a cell phone?
Thanks, Jeff. And let me add my thanks for the opportunity to be here. It's a real pleasure to be with you. The only two things I would say in amending the fact statement are the sorts of things that one puts at the beginning of briefs because the facts are important and the atmosphere can be important. So Mr. Riley may or may not have been a local college student. I never found that in the record, so I'm not sure if that's true. What is in the record is that he was a notorious member of a street gang in San Diego. Now, that was not known to the police officer who originally stopped his car, but it was known to the officer at the station who searched his phone. And the reason that the officer gave for searching the phone was that gang members are known to take pictures of themselves in gang activities or with, in particular, weapons. And so he thought it was reasonable to think that on the phone there might be photographs of Mr. Riley with the weapons that had been seized from his car, which was the cause of his arrest. And the only other slight amendment I would have is that it's not correct to say, I think, that this search of this phone led to the police first connecting Mr. Riley with the drive-by shooting that he was prosecuted for. The car that was used in that shooting was registered to Mr. Riley. There was a ticket in the glove compartment in his name. So the police he was on the police's radar as a potential suspect in that drive-by shooting long before he was stopped in this incident and his phone was searched. So that's just a little slightly different perspective on the facts. The government thinks it was legitimate to search the phone here because, as described in a case from the early 70s, but relying on law that goes back much further than that, the reasonable assumption that the law believes people have has for many years been that if one is arrested, objects that one has on one's person are going to be taken by the police, found, taken, examined by the police to see whether they are fruits of crime, instrumentalities of crime, as they say, so something that was actually used in the crime, or evidence of a crime. Fruits, instrumentalities, or evidence, those are traditional things that the police look for, along with weapons, because the other reason that the police will do a thorough search of a person who is arrested is to find any weapons that would put the officers at risk. And the court announced in 1970 that that was a categorical rule. In other words, there are some justifications for it that have to do with officer safety and the preservation and discovery of evidence. But in any individual case, you don't need to look for whether those circumstances are present. The police need a simple categorical bright line rule that they can apply in the field. And here the bright line rule is if you have something on your person, the police can take a look at it and see whether it's something that's either dangerous or that is evidence of crime. And in our view, that's the underlying principle. And so the question is, should something change about that principle because of the advent of cell phone technology? And while everyone is certainly interested in protecting privacy, in our view, the basic insight here, which is that when you are arrested, your privacy interests are already compromised, and that part of that compromise is the police are going to look at things that they find on your person. That remains true. And the fact that information that would have been searchable by the police if you carried it in paper form in your pocket is now in digital form doesn't seem to us to make a Fourth Amendment difference. In the same way that I think Professor Fisher would agree with me that if the government tried to argue that because that information was stored in digital form, it's not a paper within the meaning of the Fourth Amendment, everyone would say, well, that's crazy. It's the modern analog of a paper that you might have in your pocket. And we would say, well, that's right. But it's also right that because the police could have looked at a letter or an address book or your wallet that you had in your pocket, they can also look at the contents of your cell phone.
Okay, so we've set the issue well. And I have to say, ladies and gentlemen, this is a riveting oral argument. And I want you, after the panel today, to go to supremecourt.gov and read what Jeff Fisher and Ed DuMont told the justices in the case, because we're going to rehearse those arguments today, but it was an incredible testing of these two positions. So on the one hand, Ed DuMont accurately said, ever since the 1970s, the Supreme Court has said that when you're arrested, the police can open any container on your person to prevent destruction of evidence, protect the safety of the officer, and look for evidence and instrumentalities of a crime. And this is just like the old days. It's just like having a paper in your briefcase, and the court has said you can look at papers in briefcase. But on the other hand, Jeff Fisher told the court, there's a big difference between our cell phones and the papers in our briefcases. I'm struggling to find mine, but my entire life is contained in my right pocket, and it's not just one paper in my briefcase, but my life. And at the oral argument, Justice Elena Kagan said, I think it was to you, Jeff, she said, nowadays young people carry their lives on their cell phones. Soon young people are going to run the world. We need a new rule that will prevent the police from looking at everything in your life merely because you're arrested. So tell us, Jeff Fisher, what is your alternative to Ed DuMont's rule? What do you believe is the correct constitutional rule that would protect the same amount of privacy in the 21st century as the framers took for granted in the 18th when they said you generally needed a warrant before you could search private papers?
Well, I think that's a great way to frame the question, because I'd like to answer it in both respects, both sort of as a modern, pragmatic question, what's the right rule, and what rule best accords with the history against which the Fourth Amendment was adopted. Ed's exactly right that in 1973, the Supreme Court held that when it comes to physical items in somebody's pocket or purse, the police can look at those things. But that rule isn't quite as categorical as even it sounds. Long before we ever started debating cell phones, the Supreme Court had already carved out one exception to that rule, which is anything beneath the body's surface. So in the everyday, ordinary situation when the police pull somebody over and suspect them of a DUI, the most telling evidence that that person has on them is in their bloodstream. And the Supreme Court has held that simply because the person's under arrest doesn't mean that an officer can put a needle in somebody's arm without a warrant to test that blood. And the reason why is because the Supreme Court has said there are extraordinary privacy interests at stake. And so evidence underneath the surface of your skin is categorically different than ordinary physical evidence. And that's, in a sense, a version of the argument that we made to the Supreme Court, which is digital information is different in kind than mere physical objects. And this is so for two primary reasons. One is simply just by way of amount of information. The exponential difference between what somebody can carry in a cell phone and somebody can physically carry in a pocket, even a briefcase or a backpack, are just orders of magnitude. There were many briefs filed in the case by outside organizations that tried to quantify the amount of paper or photos or the like that could be on a cell phone, and there were estimates like 16 flatbed semi-trucks, an entire football field filled with paper up 6 feet high. And the analogies go on, so it quickly becomes apparent that the amount of information on a cell phone, at least the capacity of a cell phone, so far outstrips what somebody could have in their pocket, and then just by happenstance the police could have a right to look at, makes you wonder whether this is a difference in kind and not merely a difference in degree. And secondly, there's information on cell phone that simply doesn't exist in tangible form, at least in the ordinary world. Things like GPS tracking information, the newest Apple iOS system takes internal physiological measurements of your body to some degree, again, bringing us back to the blood draw situation in a way. Cell phones work the inside of our homes. If anyone's built a home recently, you know that you can work the appliances and the heat and all kinds of you can monitor small children in their rooms, and so cell phones do all kinds of things that even tangible objects can't. And so with all of this amazing vast quantity and array of information that might be in one's pocket, let me ask the question from a historical perspective. Is that something that ought to be subject to search incident to arrest? And while, 200 plus years ago was a different place in time, I think there's a fair, rough analogy that is worth pausing to ask ourselves about, which is the writs of assistant and general warrants that gave rise to the Fourth Amendment. The general warrants were a practice in England that when the police conducted an arrest, they often had a warrant with them that allowed them to rummage through the person's entire house, file cabinets, drawers, closets, and the like. In the colonies, the writs of assistance were a stateside version of that same practice, and that was one of, there isn't very often you can say this in the Supreme Court, but it was actually one of the core rallying cries for the Constitution and for the Revolution. The fact that the utter disdain for the fact that even if somebody is arrested or done something wrong, that is not an occasion to conduct an entire search of all of their private papers and most private possessions, which of course in the colonial times would have been held in your home or your office or the like. Now, with the advent of new technology, I think we have to ask the question, how do we protect that same privacy that the framers of the Constitution fought so hard to safeguard? And because of the nature of cell phones, because of the fact that if an officer is able to look at this, the digital information in this device without obtaining a warrant, they're conducting essentially the exact kind of search that was prohibited at the founding. Indeed, you might think it's even more intrusive because unlike searching throughout somebody's entire home, for example, on an arrest, a cell phone also gives you a search of their doctor's office, a search of their financial advisor, a search of their medicine cabinet. You can keep going. We think that that is reason why the court, as a historical matter and as a modern pragmatic matter, should say that digital information is different.
Okay, so now we've really joined the issue. And this is exciting because you're seeing, ladies and gentlemen, that this is the cutting edge of the Fourth Amendment. And Ed DuMont, Jeff Fisher has said, you may have accurately stated the laws that existed in 1973, but now, given the vast amount of information that is stored in these devices, to allow the police to look at everything on arrest is the equivalent of the writs of assistance, which the framers were centrally designed to avoid. First of all, what do you make of that analogy between a cell phone search of everything and the writs of assistance? And second, many of the justices were grappling with this question, and two alternatives emerged to prevent blanket searches. Justice Kennedy suggested, well, one thing we might do is only allow these broad searches for serious crimes, but not low-level crimes. And another possibility that emerged was, well, you can only look at evidence that's relevant to the crime being investigated. You can't look at everything. So is this like the writs of assistance? And what do you think about those two alternatives that emerged at the oral argument?
Right. I don't think this is like writs of assistance. The fundamental vice of the writs of assistance and the general warrants was that they were issued based on the say-so of a king's officer, but without any requirement for particularized suspicion. And so the vice was that you were sending officers out to root through somebody's house to look to see whether you could find evidence of any crime, something that you then might use to arrest and convict them. This is a fundamentally different situation where somebody is arrested for on suspicion of a particular crime, and then the question is, what can you do with objects that are found or information that is found on the person? So you're already in a completely different world from the writs of assistance because you're talking about somebody who has been validly arrested for a particular crime. So the analogy is not customs officers from the king going in to see whether they happen to find contraband goods in the basement of a particular colonial. The analogy might be to somebody who's arrested on the highway for a particular crime, and you're looking in his saddlebags and saying, well, what is there in the saddlebags that might or might not shed light on whether there's criminal activity going on, whether there's stolen property there, or whether there's something else that gives us evidence of crime. Now, as to the...
Do you know what? That's such a good response that before looking at the alternatives, I want to ask Jeff to respond to that. It's not like the writs of assistance. It's like looking at the saddlebags.
Well, when writs of assistance were executed and general warrants were executed, people were arrested sometimes. In the most famous case of all that the Supreme Court has referenced as this sort of pole star of that history, the Entick case, he was arrested for sedition. And they conducted this kind of general search for everything in his house. And that's exactly, and the Supreme Court has actually brought this forward to modern times already in a sense where it has already in other settings drawn the analogy to general warrants in the context of people being arrested for specific crimes like Ed describes.
Good response. So Entick and John Wilkes, the paradigm case of the Fourth Amendment privacy victim. Wilkes is suspected of seditious libel, of writing anonymous pamphlets criticizing the king. The king authorizes his henchmen to break into everyone's houses to identify the author of this anonymous pamphlet. They identify Wilkes as the author. He sues in trespass, and the court holds in this opinion that is known to every school child that general warrants that authorize the rummaging through of everyone's personal diaries are not permitted even when someone's validly arrested for seditious libel, because seditious libel just isn't a serious enough crime to justify that invasion of privacy. What's the response to that?
Well, I think the response is that the problem with these issues, well, first of all, was seditious libel, which we passed the First Amendment to deal with. So we don't have that crime here in the same way that they used to have it, fortunately. But the other point is that the evil there was that the King's officers had hunches about who was behind these pamphlets, and they sent the officers out to go rummage through their houses to find the evidence they needed to establish the cause to arrest them. So they may have been arrested at the same time, but that sequence is important, I think. And here we have a very different situation where you already have the probable cause that justifies the arrest. And so we're talking about a specific crime. Here it was possession of dangerous weapons without a permit, and you're arresting the person for that crime. That comes first, and the search comes second, and that's what distinguishes it, in my mind, from the real vice of the general warrants or writs of assistance.
We're really getting somewhere here. So the problem is not arrest. As Ed says, the framers are concerned about using phishing expeditions to identify needles in haystacks and then do the arrest. Here he says, you know who you're looking for. Your concern is just the scope of the search after the arrest takes place. So why not come up with other means of limiting the scope of the search rather than worrying about the arrest?
Well, I think two reasons. One is a historical matter and one is a modern pragmatic matter. As a historical matter, my understanding of the Entick case and other cases were that when they went to the house, they had warrants, certainly probable cause, if not warrants for an outright arrest for seditious libel. I don't think there's anything in the history that suggests that if the officer conducted an arrest first, that therefore they could do an entire general search of somebody's house. I think if that power did exist and was accepted, you'd find it time and again. I don't know why officers wouldn't have done it, but there isn't a single instance, at least that I'm aware of that happening. It's also worth, I think this vividly displays that history is helpful, but you can tussle with the particulars, trying to translate it to modern times. So maybe it would be helpful to put a couple of aspects of modern police practice on the table and modern Supreme Court jurisprudence, I think which do form a helpful backdrop for the case, and I think might lead to the questions that you asked, Ed. A couple things are important to understand before we ask the question of whether police should have to get a warrant in this circumstance. The first is that in recent years, the Supreme Court has held that somebody can be arrested for virtually anything, right down to failing to wear a seatbelt, speeding, jaywalking, littering. Any crime, no matter how minor, is subject to arrest at the discretion of a police officer. Secondly, the Robinson case that Ed has mentioned that we've talked about and other jurisprudence says that once somebody's under arrest, the police have you cannot distinguish between one crime from the other. At least that's what the Supreme Court has held so far. And that was what the argument in Robinson was. That was a case for arresting somebody with driving a suspended license, and he argued, well, then why do you have to search my body? All I'm being arrested for is driving a suspended license. You're not going to find anything. Yeah, I'd like it. You're not going to find my license. That's the whole point. And the Supreme Court said, no, every custodial arrest, once an officer decides to take it, he can do whatever search he'd be allowed to do for a murder or for anything else of the person. So against the backdrop of this world, where also the Supreme Court has added, and when an officer has probable cause to arrest somebody, we don't care if the officer is conducting that arrest because the officer really thinks, I'm going to make an example out of this person, no matter how minor the offense, or if the officer is doing it for so-called pretextual reasons. If the officer is conducting an arrest because what he'd really like to do is conduct a search of the person and root around and ask the person some questions. The Supreme Court has said that inquiry is off limits because it's too invasive to police tactics to ask why police officers did what they did. The only thing we ask is whether they had the authority to do so. So if we're worried about a world where I think the framers were, where officers, whether they did the arrest first or second or however the sequencing went, but that they could use a minor excuse as a justification for a vast phishing expedition of people's most private letters, exchanges, and thoughts. I think that this is the problem we would have if the Supreme Court condoned digital cell phone searches in this context.
Excellent. So Jeff says, never mind the sequence of the arrest. The real concern of the framers is using pretext for phishing expeditions that are hugely invasive of privacy. And he's identified these two changes that took place in the 20th century that didn't exist in the 18th. Namely, A, you can arrest people for really minor crimes like not wearing a seatbelt. And two, pretext doesn't matter, so the officer can pretend that they're pulling you over for a traffic stop, even if they really just want to be able to search your whole car. So given these two changes, he says there's a big danger of phishing expeditions using these minor crimes as pretexts. And he says we need a solution, or else there's going to be less privacy today than there was at a time when the framers didn't like general warrants. What's the response to that?
Right. Well, first of all, I didn't hear Jeff say that those were changes necessarily. They're things the Supreme Court has said recently and clarified recently that in the Fourth Amendment, the court almost always looks to objective circumstances rather than subjective circumstances, which is why it declined to get into this question about pretext, because there's too much opportunity for second guessing down the road by judges or, well, mostly by judges who are projecting what might or might not have been in a police officer's mind. So the court said, we're not going to get into that. We're only going to look at the objective facts about what was the officer entitled to do. And then the court did hold that you could have, a state could permit, not required to permit, but a state can permit custodial arrests for even minor offenses. So those are two cases that are out there. They're data points. But they don't describe the generality of, they don't describe this case, and they don't describe the generality of cases. Most arrests are not made for trivial offenses, and most arrests are not pretextual. So, and there's no argument here that I'm aware of that the arrest here was pretextual. Just to be clear about that, the officer who made the arrest here and stopped the car for having expired tags actually didn't have any idea that Mr. Riley was a gang member, so he had no reason to make a pretextual stop here. Yes, I think you can put together the amount of information that people can choose to store on their cell phones and keep on their persons with the rules that apply in the outlier cases for very minor, for custodial arrests for very minor offenses or pretextual stops, and you can say, okay, there's reason for concern. There's always reason for concern at the margins, but we're not dealing here at the margins. We're dealing, especially in this case, with a very straightforward arrest and then a straightforward search that followed it that turned up valuable information from somebody's cell phone. And we think that the state ought to be able to use that the same way they could have used information found on that person in pre-digital circumstances.
Let's hone in on the alternatives to the current state of affairs. Jeff, one that Justice Kennedy focused on in the oral argument is distinguishing between serious crimes where broad searches of cell phones would be allowed and minor crimes where they wouldn't. And as Ed just said, the Supreme Court held just a few years ago in the Atwater case that there shouldn't be a distinction between serious and minor crimes. It was okay to arrest the soccer mom whose kid wasn't wearing a seatbelt because it was too hard for the cops to decide whether some crimes were too trivial not to justify an arrest. But Kennedy seemed to want to revisit that, and in some ways he was trying to resurrect the 18th century idea that very broad searches might be justified if you were looking for murder, but not if you were looking for seditious libel. So what do you think of Justice Kennedy's suggestion that the court might allow for broad searches of cell phones for serious crimes, but not minor crimes?
Well, my recollection is even when he asked the question, I think the next words out of his mouth were, but I'm not sure we can do that under our cases. There's something to that effect. And so as the Atwater case illustrates and as Robinson illustrates, the court has not only never done that before, but it's outright rejected any possibility for distinguishing serious from minor crimes, and for lots of pragmatic reasons. It's often difficult to tell when somebody's arrested whether it's a, quote, I don't know how you decide what's a, quote, serious crime or a minor offense. I will say, just to clarify something Ed said about minor, trivial, whatever adjective you want to use. There are about 11 million arrests a year in this country, and the majority of them, and depending on the state you're in, somewhere 2/3 to 3/4 of the arrests are for misdemeanors. Things like DUI, which is the most common crime of arrest in the country. Is that a serious crime, a misdemeanor DUI? I mean, would the court have to go literally through the code of every state? What about a white-collar offense like tax evasion? Imagine the treasure trove of information an officer would think would be in a Wall Street executive's BlackBerry. Is that a serious crime? Should a warrant be required there? I think the court would be entering a hornet's nest with a serious versus minor crime question.
And I won't assume, but I'll ask you whether you disagree with Jeff that a serious trivial crime distinction should be resurrected. And if you don't disagree and you think that's not a practical distinction to resurrect, what about the other suggestion that emerged at the oral argument, namely that the police should only be able to search for evidence of the crime for which the arrest occurred? If there's reason to believe that you'll find evidence of the crime of arrest, but not have a broad and unregulated search.
Right. I don't disagree with Jeff about not resurrecting the serious minor crime distinction. I will note that Michael Dreeben, who is with the Federal Solicitor General's office and argued for the United States in a companion case here, did mention that the court has drawn a serious, non-serious distinction in at least one context, which is whether the police are entitled to enter a home in order to say in hot pursuit of a criminal. And I think that they may have drawn the distinction in that case that if you're pursuing a murderer, you can go into the home. If you're pursuing somebody who is suspected of having vandalized a stop sign down the street, you can't. So there may be some precedent for it, but I don't think it's probably the right way to go. And in most circumstances, the court has refused to go there. I think this question of the crime of arrest, limiting a search of objects even that are found on the person to circumstances where the officer can reasonably be thinking that he or she may find evidence that's relevant to the crime of arrest, that has a good deal of historical pedigree. It has not been the rule since 1970, but if the court is looking for a limiting principle, then what we told the court in our brief and at argument was that one has some significant historical pedigree. We think there are a couple of important things to understand about that. One, you would have to, again, you'd have to use it in an objective sense. The question needs to be what could a reasonable officer in these circumstances have been looking for, and what could this person have validly been arrested for? So you can't be limiting it to the particular thing that may have been written on the booking sheet as this is what I arrested them for. You need to go beyond that and say what are the whole circumstances and objectively what could a reasonable officer in this situation have done. And the second thing is there needs to be what a lawyer would call a plain view concept here, which is if I'm looking, as the officer was here, for reasonably looking for photographs that might show the defendant, the person who's been arrested with weapons that were the cause of the arrest. So that's directly linked to the crime of arrest on the facts here. But if I'm looking for that reasonably, and I'm in a place on the phone where I could reasonably be looking for that sort of information, if I see something else that is relevant to a crime, I need to be able to use that. You can't bar the police from then using that. And the analogy there, the reason it's called plain view, or that I use that term, is that the analogy here is if the police are making a valid arrest, for instance, in your home, which is normally where the height of Fourth Amendment protection applies. But if they're there for a valid reason, and they look down and see a gun sitting on the table or some other piece of contraband or evidence, they don't have to have gone in to look for that or to have had a reason to go in to look for that. If it's in plain view in a place where they're otherwise authorized to be, the police are entitled to take note of that and to act on that information. And you need to have the same sort of principle here. But if you have those two things, then we don't think this is the rule that the court's current cases dictate, but if they are looking for a limiting principle, this would get rid of the seatbelt arrest or the jaywalking arrest and being able to look at your phone for that while leaving proper scope for reasonable searches.
Jeff, what about the limiting principle that Ed suggests and that some justices seem sympathetic to? You can search a cell phone if you're looking for evidence of the crime of arrest, but you're allowed to seize and look at any material on the phone that you find in plain view in the course of that search.
Well, the only problem with that is that it's not actually a limiting principle. It may sound appealing on the surface, but precisely because of the incredible amount of information we all have on our smartphones, an officer in virtually every arrest, we think, if at least as the state and the United States government have described how this test would operate, officers would almost always have a reasonable suspicion that something on the phone could be relevant to the crime of arrest. Take speeding. The GPS locational information on our phone keeps track of our whereabouts, and there are cases already where people are challenging speeding tickets by use of their iPhone because it shows that they didn't travel from point A to point B fast enough to have been speeding. DUI, again, the most common crime of arrest. An officer could say, oh, you might have had photos with you out with your buddies at the bar having a beer in your hand. You might have sent a text to your spouse saying you're going to be home late because you're stopping at Joe's Tavern. You can go right down the list of ordinary minor crimes, not to mention serious ones. And if all an officer has to do is articulate some reasonable suspicion that somewhere on the phone at this vast treasure trove of information, there'd be one speck of evidence that might be relevant to the crime of arrest, I don't think we've created a limiting principle at all. And then that leaves you with the problem that the only possible solution would be to somehow curtail the search to limit it within the phone to only certain areas, or impose restrictions, as one scholar, Oren Kerr, has argued under this approach, under the plain view doctrine that Ed was just discussing. I won't go into detail about these possible restrictions, but I think that you just take an unwieldy solution and make it more impractical when you try to do this.
Good. Well, let's dig into Jeff's response that this is not really a limiting principle because anything on the phone could be relevant. First of all, I want to say, look at this beautiful stack of substantive, intelligent questions, all of which are directly on point. I'm so proud of our great NCC town hall audience for following this argument so closely, and I'm going to start to weave some of these in. Ed, one questioner said, could we protect certain pockets of the saddlebags, i.e. only texts are applicable and not voicemail or email, only currently not archived data? It's a broader way of asking you. There's got to be something more than the information could be relevant, and there's a lot of possibilities floating around, distinguishing among kinds of information, as Professor Kerr has suggested, allowing everything to be searched but not everything to be used, or I'll just put on the table the most comprehensive effort to come up with an alternative to blanket searches. Judge Kaczynski, in a famous case involving drug testing, said, when you're dealing with computers or cell phones, the government should forswear reliance on the plain view doctrine, because otherwise it could get anything. There should be neutral magistrates who would look through and decide what's relevant and what isn't, and basically you'd have some third party supervising the scope of the search to make sure it wasn't out of control. A lot there, but what do you think of some of these alternatives?
Well, to start with the audience question, I think what you see from the transcript of the argument is that the justices were themselves reaching around for, is there some sort of limiting principle like that? And I think there may be some out there. The United States, in its arguments, tried to offer some, a couple of which had to do with the scope or so-called intensity of the search, which would be ways of trying to get at this idea that maybe you can look at the surface, but there ought to be a limit to how far you can drill down. Justice Sotomayor, in one of her questions, suggested a sort of variant on the plain view, which is, well, you can look kind of at the surface of the phone, the wallpaper, and recent texts, but maybe there could be a limit there. First of all, we don't think that that corresponds to current law, so we think those are all advances over current law. But if the court is looking for some kind of limiting principle, we think that the crime of arrest limitation is the best historically founded one, and we do think it's a real limitation for some of these same reasons. So that if, for instance, you have the speeding situation or the DUI situation, there may very well be ways that you can articulate, an officer can articulate why some information on the phone would be relevant to that offense. But it's only going to be some information, right? If you're thinking about GPS information for speeding, or recent texts or recent photos that might be relevant to a DUI to see whether within the last hour you were at a bar with your friends and took a picture or something like that. You know, there may be things you could look for, but it wouldn't extend to pictures from 2 weeks ago. It wouldn't extend to your emails probably. There are lots of ways that you can see that there would be common sense limitations on the search that would be real in that circumstance. So I guess I don't agree with Jeff that that's a meaningless limitation.
So Jeff, we could sit here as legislators and try to come up with an ideal set of limitations, but the criticism of the whole enterprise, and Judge Kaczynski's opinion was criticized for this, is the Supreme Court shouldn't be making essentially legislative limits on these searches. That leads to this question. With the existence of exigent circumstances and other Fourth Amendment exceptions, why is it necessary to perform a warrantless search when a phone is inventoried and a warrant could easily be obtained? Is it your position that rather than coming up with these complicated limits, a warrant of a cell phone search should be required in all circumstances, period?
Not in all circumstances, and I think the question, in the court, that's what we might call, if it were asked to me, the softball question. So that question well articulates what my position is that it's not a categorical requirement that officers obtain a warrant, but that should be the general rule. If there are exigent circumstances, which is a term of art in Fourth Amendment jurisprudence, that basically means there's some sort of emergency situation that if the officers don't conduct the search now, in other words, don't conduct the search right away without the time it would take to process and get a warrant, that they might lose access to the evidence. There were a lot of technological debate in this case that we haven't touched on today yet about various technologies and the like connected with cell phones that might, under certain rare circumstances, make that legitimate for an officer to search a phone without a warrant. That's not this case, though. This case is a search conducted 2 hours later at the station house, and it would be certainly enough to dispose of this case and its companion for the court to say, at least when it comes to station house searches, officers need to obtain a warrant. And I think, two other very quick things. Just on the question, Ed, was on the possible limitation of crime related to the arrest. The difficulty with that is if it's a DUI case and the officer thinks he can check my text messages or most recent emails, well, I got an email yesterday confirming a doctor's appointment. I get text alerts from my bank when deposits are moved from one account to the other. So the interwoven nature of everything on a cell phone, I think, makes it incredibly difficult to administer. And so then what do? Well, I think there is already a limiting principle, and it's in our Constitution, which is the warrant requirement, is that go to a magistrate, ask for a warrant. The magistrate can explain what is allowed to be looked at, what isn't, what is allowed to be used in a prosecution, what isn't, and also something we haven't touched on today, what can be stored and kept in perpetuity in the police department or whoever may have access to this information. Remember, we're not just talking about picking something up and glancing at it and forever losing it. Presumably, if officers can conduct searches of digital devices, they can download all the information they look at and keep in perpetuity in their own databases for whatever future purposes they might want. Warrants in states that have adopted a warrant requirement already have been used to some degree to regulate that as well.
So Ed, this question says, connecting cell phone data with the government's ongoing data mining can produce an accurate, albeit intrusive, profile, so the collection of phone data provides much greater insight than would the collection of any amount of papers. In the oral argument, the GPS case, Jones, came up, and in Jones, as you discussed with the justices, the court held that surveying someone's movements 24/7 for a month, there was a disagreement about the reasoning, but might require a warrant just because it can reveal so much more than an ordinary search. What was your response, and is your response to the question that the search of a cell phone is like 24/7 GPS surveillance, and therefore a warrant should be presumptively required?
So what we tried to say in our brief and in the argument is that we understand the extra volume of information that is now often carried on cell phones, and in particular the connectivity aspects of cell phones that may make them, in fact, qualitatively different from what's come before. And so we are sensitive to those and the privacy implications that they may have. We don't see those implications being present in this case. And although the justices don't usually like and did not like in this argument, the answer that you should wait for a case that presents those facts before reaching a conclusion about that, that really is California's position on this. That in the kind of information we're talking about here and the scope of the search that was conducted in this case seems to us to be quite directly analogous to things that somebody might have had in his pocket in paper form, and the digital form by itself should not make a difference. If there comes to be a case where a much more detailed search is done, a lot of data is mined, and then particular pieces are taken out of it and put together in a new way, something that really is a qualitatively new and different kind of search made possible by modern technology. That, I'm not saying what our position would be on that, but I can say that I think it would be quite a different case. And that's really what we tried to say to the court was, number one, you should wait for a case that presents facts like that before trying to decide in the abstract what the rule should be. And the other thing that we suggested was that in many of these contexts, like wiretapping, for instance, when that was a brand new technology, what the court has really done is step back as a constitutional matter and allow legislatures to think about these issues and think about the particular ways that the democratic process may want to balance people's evolving privacy expectations and the continuing needs of law enforcement. And we think that's a much better and more flexible way to go than having the court adopt some constitutional line in the abstract, which will then either be outdated in a couple of years or be inflexible in the way that it's applied.
So Jeff, the court was obviously concerned about the question Ed raises about not constitutionalizing a rule as the technology is changing. And there was a lot of discussion about whether password protection should matter, whether you could destroy the evidence on a cell phone by putting it in a Faraday bag, which, by the way, Julia Angwin came the other day.
Keep it from being destroyed.
Keep it from being destroyed, but that's right, it protects it. You can't remotely swipe it if it's in this cool bag, which a new author, Julia Angwin, came and showed off this Faraday bag, which has become a de rigueur fashion accessory for the privacy conscious in the digital age. But why isn't Ed right that, wait for a case where the court, where the police search your cloud data or assemble all of your geolocational data? This isn't that case, and therefore you don't need a broad rule.
I think two things I would say to that. First, in fairness to Ed, I understand that's an argument often made when it comes to new technologies and new problems. At the same time, the argument that the state and the United States is making, and this is where Ed started today, is that there's a categorical rule that if you're carrying it, we get to search it. And that's the guts of the argument on the other side. And so that argument admits of no limitations or exceptions. And so in a way, I think invites the broader debate. Now, you could still say, well, whatever, the court should make its own mind up. I think the wiretap history is instructive, as in other areas. Legislatures, setting aside whatever we might say about our current Congress's ability to get stuff done, Congress and state legislatures have sometimes gotten into fields like this, and they've been helpful, but usually not until the court at least decided a case or two to lay some basic ground rules. So the court, I think, needs to say, as a very fundamental matter, whether digital information is different than physical information. I'm sitting here saying it is, and the governments in this case are saying that if it could be printed on a piece of paper, the fact that it's on an iPhone is no different. That's a Fourth Amendment question I think the court ought to step in and say something about. There is a footnote in this case worth mentioning, I guess, which is California was actually one of the few states whose legislatures did try to get into this game. Before Ed was in the position he's in now, in response to the California Supreme Court decision I mentioned earlier in the program a few years ago, the California legislature overwhelmingly passed a statute that would have required officers to obtain a warrant before searching any digital device. And Governor Brown vetoed that law, saying that this is a question for the courts. So even when legislatures have tried to get into this game, I think that the governor, and I'm not trying to poke fun at anybody, I'm just saying I think that this is an area where, at least as to the first or second fundamental ground rule, before we get into the fine tuning, legislatures and policymakers want to hear first from the courts, and then maybe, and you might say hopefully, they'll get into the game.
Is that backward, Ed? Should legislatures work out the detailed rules first and then courts can ratify them? My GW colleague Oren Kerr has said all of the big advances for privacy have come first from legislatures and then courts piggybacking. So would it be better to solve these questions we're talking about legislatively rather than having judges make up the rules on their own?
Well, I think it's considerably more flexible. Legislatures are better, more able to hear and assimilate a lot of information over whatever period of time they need to take to think about it and come up with rules that don't have to be justified on as categorical a basis as constitutional rules have to be. They can be democratic compromises. So a legislature can legitimately say, well, we see the interests on both sides here, but we are going to draw the line here. And that's the way the democracy is supposed to work in most instances. The Constitution provides a baseline, a very important baseline, but it's a sort of minimal floor of protection for liberty and rights. And what we have to be careful about is having courts get into areas that they don't fundamentally understand very well, that they can't take the kind of legislative approach to where they really bring in information from all sources, and where they have to issue decisions that are then going to be applied like this Robinson case was for the next 30 or 40 years. So they have to be drawing relatively bright lines and lines that are not going to be as nuanced as what a legislature can do. And there are many, many things in the law that are, or in society, that are undesirable but not unconstitutional. And for those things, the proper forum is to go and persuade your legislature to adopt certain kind of rules that then can be adopted in a more nuanced way and then can be changed as the technology changes much more easily than constitutional lines drawn by the Supreme Court can be.
Okay, time for closing arguments in this completely fascinating discussion. At the Constitution Center, when discussing privacy and technology, we always ask a simple question, WWBD, what would Brandeis do? Louis Brandeis, the great theorist of privacy in the age of changing technology, insisted on translating 18th century values into a 20th and 21st century world. Jeff, you can do this as well, you've told the court what you think it should do, but if you were a legislator, what's the right rule? You've seen what various legislatures have done. You mentioned California. What is the proper rule that a legislature should adopt for protecting as much privacy in the age of cell phones as the framers took for granted when it comes to cell phone searches?
Frankly, I think the right rule is the one that we're propounding in this case, and I don't mean to make it sound just so happily coincidental in that respect. Remember, the Fourth Amendment uses the word unreasonable, and so the kinds of balancing between privacy and security that Ed's talking about are actually already built into the Fourth Amendment. So I don't think it's a coincidence that what I'm going to say is that I think that the rule should be that digital information is different, and so therefore police officers should have to, generally speaking, obtain a warrant before searching the contents of digital devices, unless there's some exigent circumstances that would make getting a warrant impracticable or too time consuming.
Ed, WWBD, you've told the court what it should do. If Jeff's rule were adopted by a legislature, would that be okay? What do you feel is the correct way to protect privacy in this age of changing technologies, and who should do it?
Well, as Jeff said, the baseline Fourth Amendment rule is that there's a prohibition on unreasonable searches and seizures. So I think the point here is that when police make a valid custodial arrest for an offense, the question is, what is it reasonable for them to do? And we think it is reasonable in the baseline case for them to search the person for weapons and for evidence. And if they find a cell phone, if there's a reason to think that there is evidence or something that might be dangerous or relevant information on that phone, it's reasonable for the police to look for that information. And that's the right rule. Now, if there are safeguards to be put in place because we're afraid that because of the information that some people choose to carry on their phones, a search or the use of the information made after the search might become unreasonable in some circumstances, then legislatures should think about that, and they can adopt rules. But the baseline rule is going to be that when there is a reasonable arrest, a valid arrest, a search incident to that arrest is going to be reasonable in the constitutional sense, and that's going to include looking at things that you have on your person at the time you're arrested, and that includes your phone.
Ladies and gentlemen, I told you I'd like you to go to the Supreme Court website and read Jeff Fisher and Ed DuMont's argument before the court in U.S. v. Riley. You'll find it in the oral argument section, but I can assure you that the quality of that extraordinarily high oral argument was no less than the amazing discussion you've just heard today. Please join me in thanking our panelists.